While so many of us love searching for a good dupe when we're looking for a good deal, a cheaper version of a more expensive product can get a lot of major brands into some major legal trouble. In one of the most recent examples, fitness apparel company Lululemon sued wholesale retailer Costco over its athletic wear, accusing the company of unlawfully taking advantage of Lululemon's reputation. The lawsuit argues that Costco is copying instead of competing. Costco has not yet responded to Lululemon's accusations, but the battle has added to the debate over the legality of selling these lower-priced duplicates. Susan Scafidi joins us now. She's the founder and director of Fordham University's Fashion Law Institute. Susan, thank you very much for joining us. I find this really interesting because everyone loves a good deal, but cheaper versions of pricey retail items, they're so normal these days. Can you explain what's allowed and what's not allowed?
Well, if I could do that, then we could all retire. But what you're not allowed to do is cross over the line into someone else's protected intellectual property, which can take a number of forms. It is difficult to protect clothing in the United States under intellectual property law, but there are some boundaries. And Lululemon is claiming that Costco has crossed those boundaries. There is no copyright claim here. Copyright is about literary and artistic works, so maybe fabric prints, but there are trademark and patent claims. So we've got trademark claims with regard to not the word Lululemon or Lululemon's Omega type graphic logo, which are not at issue in this case because Costco is not accused of copying them, but the actual shape of some of the garments and the curved seams that appear in those garments that serve as trademarks, as well as design patents on some of those shapes, and a separate word mark for the word scuba, and another for the color, the name of the color, Tidewater teal.
You know, it's so difficult, though, sometimes when you talk about these designs, and sometimes you could just say, this is what athleisure looks like these days, and this is not really a design aspect, but this is just what people want. When this actually does go to court, where do you see this going?
Well, one of the clever things that Lululemon did in its complaint is show that there are hoodies and casual men's trousers out there that it isn't suing over, that you can create the same kinds of things that Costco has sold without actually crossing over the line to infringement. So where do I really think this will go? Well, sort of like the house always wins, the case always settles. Not always. From a legal perspective, it would be lovely to see what a jury had to say about how close is too close, but we're not like at that.
Susan, I also want to ask you about this. Another example that is making a lot of rounds here. Walmart making what customers have deemed the Workin, a lookalike version of the very expensive Hermes Birkin bag. Is there anything that higher end companies can do to prevent other brands from allegedly duplicating their products?
Well, Hermes, like Lululemon, has actually registered trade dress, including on the Birkin. So the Walmart Birkin, when people were out there working it, was in fact something that was very much protected, which is why that case went away very, very quickly, and the product disappeared from the Walmart website. Um,
Yeah, you do
so
see those similarities very obviously
yes.
right there.
If you can convince the US government, the trademark office or the patent office to register it for you, you're halfway to winning your case. So in some of the examples here, Lululemon has already done that.
So why is this such a legal gray area? And it seems to be changing by the year.
Well, in the US, we have copyright, patent, and trademark, but we do not have what our colleagues have in Europe, and that is a fourth category of design protection for things that are both functional and have some kind of individual aesthetic component, right? So that's most consumer products. So it's really hard to protect clothing. So brands keep trying, which is why Hermes, Lululemon, well-capitalized, well-known brands are trying to stretch US intellectual property law to cover, and it's not easy.
Yeah, we joke about this, but there's such big money involved in all of this. Susan Scafidi, thank you very much for joining us.
My pleasure, Nancy.